Live.
Okay, all right. Good morning, everyone. This is Snre Natural Resources and Energy, and it is Wednesday, March 26th. And we are getting a preview of a bill that we don't have possession yet, but we'll be hopefully coming over soon about miscellaneous A&R subjects. So we're going to start out with a walkthrough. We'll have the presenter in once we have possession. Yeah, come join us at the table. And then we're gonna hear from a lot of folks about things that are in it.
Do you want this on the screen?
I think it is okay to not for
Okay.
now.
They're posted on the website.
All right, then, this is Michael Grady, the state council. I'm gonna walk through an act relating to miscellaneous environmental subjects, which is page 319. That has past version, that's not formalized by the clerk yet, probably today or tomorrow. There was one minor amendment in it on the floor, and then we'll keep that out and go through. On page 1, section 1, you're in the section related to the battery extended producer responsibility program. As you likely all know, the state has a battery program where manufacturers are required to implement a collection plan through a stewardship organization for the free and convenient collection of batteries from consumers. One of the things that you would ask A&R to do is to report on how to, in the future, manage certain types of batteries that are not currently part of the program because of their complexity and difficulty potentially in managing, including batteries and hybrid and electric vehicles, battery sheet energy storage systems, and batteries that are not easily removable from products. The stewardship organization is going to now be the one that reports on that, how they would contemplate bringing those types of batteries into the program, and they've asked for an additional year in order to submit that report. So on page 1, 9, 10, and 11, you'll see the report is changing from the Secretary of Natural Resources to the Stewardship Organization, and the date changed from July 1, 2026 to July 1, 2027.
There's a question here, yes?
What's a stewardship organization?
So it's a requirement under the extended producer responsibility programs that manufacturers either working together or working potentially as just a small group or one have an organization that assumes the responsibilities for the manufacturers in collecting and managing whatever the waste product is.
Okay.
And there are requirements for the stewardship organization. Do they have feasibility? Do they allow for easy access to membership? Can they basically stand themselves up? So that's what the stewardship organization. You're going to see one in the
Okay, thank you.
On page 2, line 8, you're now in the section related to fuel storage tanks. This is related to the standard for delivery of fuel to category 1 tanks. Category 1 tanks are underground storage tanks, except for farm and some residential underground storage tanks. Hopefully underground storage tanks for residential being beat out, but there are some. And instead of right now, they're having to be the tank visibly designated by the agency as not having, not meeting the standards for delivery. It's going to be, and think about that, these are category 1, they are underground. How do you know if it's visibly corrosion or so? Instead, it's going to be, they don't have a valid permit. That ends consequently because they may result in the tank releasing a regulated substance to the environment. That's something that a fuel dealer can check before the delivery instead of arriving and trying to determine if there's a visible issue with the tank that would prevent delivery. On page 2, line 15, you are in the sections related to the Household Hazardous Waste Extended Producer Responsibility Program. Last year, you set up a program requiring manufacturers of covered household hazardous products to set up a producer responsibility program where, again, manufacturers working together under stewardship organizations offered free convenient collection of covered household hazardous products for ultimate disposition or disposal. The program is one of the first in the country for this scope of products, and there has been some just more time needed to implement and figure out how to manage the program. The next few sections you're going to see where the manufacturers, instead of initially implementing a full-fledged plan, like the plans that you usually require for these programs, they're going to have an initial plan. It's kind of a short and truncated plan for 3 years to try to figure out what they don't know. Because right now they don't know how to run this program. They're going to try to figure it out over the 3-year truncated plan. And then after 3 years, the full-fledged plan goes into implementation with all of the requirements that you had in your plan last year when you passed the bill. So first, you'll see that there's a clearer sale prohibition on page 3, line 18 through 21. A manufacturer of a covered household product, this product shall not sell, offer for sale, or deliver to a retailer for subsequent sale of covered household hazardous product without registering with the stewardship organization pursuant to subsection C. So everyone that has these products has to be registered with the stewardship organization. And then page 4, line 1 through 5, nothing's really changing here, but this is how the plan gets implemented. It's 6 months after a final decision on the adequacy of the collection plan by the secretary that the plan is implemented, and the retailer and the product have to be covered. The manufacturer and the product have to be covered by the plan. And moving down on the bottom of that page, you'll come to line 18, subsection B. This is where the stewardship organization is required to register with the secretary. It says July 1, 2025, they shall file a registration with the secretary. So that's July. But the initial information that they're going to provide, the list of manufacturers, brands, et cetera, that's moving, and that's going to move into the plan requirement. And then at the bottom of the page 5, you'll see where the truncated initial plan is implemented. So beginning July 1, 2026, and annually thereafter, a stewardship organization renews its registration. So that's the renewal of the registration by the stewardship organization. And on page 6, you get.
Sorry, yeah.
Michael, just what is the practical difference between the language at the bottom of page 14 and thereafter, and what happens in page 5? It will look to me like they're saying the same thing.
There's not a lot of difference. There's
Okay.
just movement and kind of timing and functionality. So what is provided by in the registration is the same. So beginning July 1, 2025, they register, but they don't have to provide everything.
Yeah, I see why.
Beginning July 1, 2026, they have to renew their registration, and then they have to provide the list. So July 25, we've got a stewardship organization. They don't know everybody that's in their program yet, because remember, these are a lot of products. Now in July 26, they know more fully who's in their program, and that's when they provide the list and all the information that's on page 6. And then on page 6, on or before November 1, 2025, a manufacturer shall register with the stewardship organization. So you see kind of how the manufacturer's registration plays into providing the information that's on page 5 coming up to page 6. Then you get to the collection plans, section 5, page 7, lines 6 through 9. You'll see it's the initial plan. But the initial plan shall last for a period not to exceed 3 years. And you'll see that That is the date for that changes, and it's at the top of page 7, it's on or before July 2026. They shall coordinate and submit to the secretary one collection plan. So the initial plan is that first one, it's 3-year one, it still has to provide 3 statewide collection of covered household hazardous products. And it still has to reimburse municipalities when a municipality provides for that free convenient collection. But all of the other information, the criteria that you usually include in a collection plan is being struck on page 8 and 9 and 10. And it's not going away, it's just being moved. And so that's all of what is being struck from the initial plan. The initial plan still does have to, on page 11, outline how it will fund implementation of the plan, including all municipal collections offered to the public in the base program years. But then on page 12, you'll see the subsequent plan. It's after that initial 3-year period. They've run the program, they've collected the information, they know how they're gonna do it, implement it, they'll know where their collection sites are, they know how they're gonna dispose of these products, they'll know the scope of these products, and so that's when the typical requirements for the plan kick in, page 12, 3 years after the initial term. We don't know the exact term, because remember, the initial plan is going into effect 6 months after the secretary approves its adequacy. So you don't know when that time frame is. I expect later, let's say in the years, you might get a more clear answer to that. But right now, you don't know the specific date when that 3-year time frame will expire. But when it does, you get all the stuff that you normally get. You know, the list of participants, the free statewide collection, convenient, free, accessible collection opportunities. The stewardship organizations shall accept all products collected from a covered entity, shall not refuse the collection of a covered household hazardous product, including orphan products where there is no manufacturer that's registered as part of the stewardship organization. The collection program shall also provide for the payment of collection, processing, and end-of-life management of the products, including facility costs, labor, supplies, maintenance, events, all of that a municipality or a collection site might incur acting as a collection site. There has to be convenient location. They have to basically build that in. The plan shall make efforts to site points of collection equitably across all regions of the state to allow for convenient and reasonable access. There has to be public education and outreach. This is all stuff that was in the plan last year. It's just being moved. So page 15, line 3, there has to be compliance with appropriate environmental standards. There has to be a method of test disposition. There has to be performance goals. There has to be on page 16 at the bottom of the page, collection plan funding. And that's the collection plan. Again, what you required last year, moved forward 3 years after that initial truncated plan. So the manufacturers, the stewardship organization knows what they're doing more clearly. On page 17, line 17, section 6, this is some of the tweaking to the stewardship organization requirements. And it's really to add authority that they typically have built into their membership. It's page 18, line 12 to 14, to authorize them to charge its members reasonable fees for organization, administration, and implementation. That's how these programs work. The manufacturers join the association and then agree amongst themselves how they're going to assess the fees for the cost of the programs. I think because of the scope of this program, setting forth that they have that specific authority may help them in assessing these costs to any registered manufacturer. Section 7, page 18, line 15 is the agency's responsibilities in running this program. One of the things that's being added, there's concern that maybe the manufacturers, the stewardship organizations don't get to a point where they can submit an approved collection plan. And as such, you're giving A&R the authority to issue their own collection plan. And if they do, to assess those costs on the manufacturer plus the 10% assessment on top of it, kind of a incentive not to pay that, so to get your own plan approved. The agency, I can't remember what other program the agency has this for, in late Vaudeville, yeah. Page 19, line 16, section 8. This is an amendment to the landfill disposal requirements. There's one section in the law that sets forth what cannot be disposed of in the landfill.
Can I interrupt you here really quick? I just want to again, just be clear, this section G on page 19, again, this is not new, this was a part of existing law, it was.
No, this one is
Oh,
new.
this is new, okay,
G is new.
okay,
You're specifically giving A&R this authority that they
Yes.
have not had before. And I think that's because of the anxiety of whether or not the stewardship organization can get to a point where it's going to have an approved collection.
gotcha, right, there's an incentive basis for them to do it.
There's a way for the agency to implement, and the agency has implemented collection plans in the past, most notably the electronic waste plan, but you told the agency to do it that way.
Right,
You didn't tell the manufacturers to do it first and then the agency if the manufacturers couldn't do it.
I think this is why I was having a little deja vu, I was like, I know we've done this before, okay, well, thanks.
The landfill disposal requirements covered household hazardous products. Moving it out one, because remember the date of the collection plans is moving. So you wanna not prohibit the landfill disposal until there's a viable program, at least in the July 1, 2026. And then on page 20, section 9, under the existing A&R rules, there are requirements that municipalities hold at least 2 collection events for household hazardous waste or have a permanent facility for the collection of household hazardous waste. With this program coming and with the cost of these events, the agency wants to build in some flexibilities for municipalities to have options for fulfilling the collection event requirements. And so you will see the municipality can they can get a variance from the 2 collection events if they show that they have partnered with another municipality that allows residents the ability to access a permanent household hazardous waste facility in the same manner as the municipality that operates the permanent household hazardous waste. Municipalities partnered with a nearby municipality to offer collection events to members of both municipalities. And this, after that semicolon, is where the amendment was made on the floor. There was an or that was added on page 20, line 13 at the end of subdivision 1. So these are 3 alternatives. If someone was reading them as you had to comply with all of those things, and that is not the case. And then the municipality has demonstrated that it has made reasonable efforts to provide alternate collection opportunities. It's unable, and the cost of the collection event is unreasonable. In that circumstance, A&R may reduce the required collection events 1 per year. This entire section is repealed July 1, 2027. Remember, we're going to have a stewardship plan and program in place, hopefully by then, to replace the need for the covered household events. So page 20, line 20, section 10. There was an ARPA program called the Healthy Homes Initiative that provided money through A&R to, or DEC specifically.
Oh, I guess there's
Sorry
in
to
here,
go
yeah.
back, but on the bottom of page 1, what happens if there isn't a replacement plan in place and this is repealed?
Well, you'll probably get notice of that, sometime before July 1, 2027. We'll look for an extension of that sunset.
Another question?
And, you know, this is probably gonna get answered in follow on, but thank you for this, good. Looks like a good plan, but people will be thinking about municipalities. Because they usually host these days. And they have to put extra people on, and, you know, the transfer station happens to be on a postage stamp, so. We have problems, we have to hire traffic control, so is there any kind of a fiscal note that goes with this?
So part of the point of this plan is to not have the self-defense management districts ultimately be responsible for paying for those events. But we can, I'm sure we could probably.
Well, we're not, I mean, I think the municipal solid waste center takes care of that, like in my municipality, 2 days a year. But when they show up at the transfer station, they have other problems that they have to deal with for traffic control.
Well, let's come back to that
Okay.
as an issue, because that's part of the point of it, actually, so. But I'll let others speak to that. Great.
So there was an ARPA program that provided money to DEC to issue grants to make repairs or improvements to drinking water, wastewater, or stormwater systems. For those homeowners who have low to moderate who live in manufactured housing communities. Part of that program was supposed to be privacy and who received those grants, that assistance. As a term of the federal appropriation. Vermont's Public Records Act doesn't really have clean exemptions that would prevent or allow the public agency to withhold that information. So this is on page 21, lines 10 through 16, providing that all information is submitted to or compiled by DEC related to the issuance of individual funding awards under the Health and Human Initiative shall be considered confidential. Unless the person providing the information designates that it's not confidential. This shall include personal information of all applicants that request to receive funding, notwithstanding the retroactive. Notwithstanding the provision in law that all laws are prospective. That's going to be a 1814. The subdivision shall take effect and impact decision shall apply retroactively to July 2023.
Oh, yeah, sure.
I'm assuming though that de-identified aggregate data is still allowed.
I do not know the specifics of the condition in the Healthy Homes Initiative ARPA funds. But I think as long as they can do it without identifying who it is, because there are situations even when you do aggregate, you can disclose the information. The healthcare industry has a term for it. I can't remember the term for
I
it.
can't remember either, but I know, yeah,
But
especially in a small state where you can kind of figure out.
when there's only a couple of manufactured homes and maybe
Yeah,
only a few of them receive this money, that they could be identified quickly and you could identify them. You might not want to disclose that kind of information.
okay. I'm just wondering for me, to the extent that we do kind of program evaluation to know, 100 people were served and fixed
I think
the homes
you're gonna-
by doing X, Y, and Z to them. Kind of that kind of.
I think you should inquire of the agency whether they can do that.
Okay,
My intuition is yes, but I don't see.
okay, thanks.
Last year, in Act 121, you enacted multiple provisions regarding river corridor mapping, river corridor development, national flood hazard, flood safety standards, wetlands and dams. And these next few sections effectively move the deadline for all of those requirements, generally by a year. And so that's what every section until the very end does, to the very last section. So section 11, this is in Act 121 regarding DEC's amendment of the procedure for the statewide river corridor base map. So this is pushing this from January 1, 2026 to January 2027. Similarly, page 22, line 10. Pushing from January 1, 2027 to 2028, when DEC will do its education and outreach program on river corridor development. Page 22, line 20, 21, pushing until 2028. The report to you on education activities and input that it received. Going down page 23, line 16, section 12, pushing from July 1, 2027 to July 15, 2028. The deadline for rules that establish the requirements for development in map river corridors. And then on page 24, line 15, the deadline by which a permit will be required to be obtained from ANR to commence or conduct development from January 2028 to July 1, 2029.
There are,
Sorry, go ahead,
like
yes.
a lot of things in the rule, but what was the rationale for the extra 15 days?
As I said, generally the times a year, there are a couple where.
What's the rationale now?
It's just what the agency gave.
Okay.
Those extra 2 weeks.
So that's.
People are on vacation for Well, this, the one at the bottom, it's 24 is more than a year.
It's,
Like a year and a half.
it's, yeah, it's a year and a half. On page 25, line 4, section 13, this is the study committee on state administration of the NFIP program, the National Flood Insurance Program. Remember, the state currently has like a recommended standard, but it's not fully mandatory. And you're going to study whether or not the state should be running it instead of municipalities. And so that report is due to you August 15, 2026 instead of August 15, 2025. Page 25, line 13, section 14. This is just an implementation section in the bill, and this is just changing a date you've already seen, the rulemaking for river corridors from July 1, 2027 to July 1, 2028. Section 15, again, is an implementation section, moving the compliance with the state flood hazard area standards from January 1, 2026 to January 1, 2028. Page 26, line 5, section 16, this is moving from July 1 to December 1, 2025, the ANR amendment of the wetlands rules to include the goal of net gain of wetlands to be achieved through protection of existing wetlands and restoration. And then similar change, page 26, lines 19 and 20, incorporate the net gain rule into requirements for permits beginning December 1, 2025. Which will, there might be a little bit of a gray area there depending on when the effective date of the rules are, because the rules are generally effective 45 days after LCAR approves them. So LCAR is probably going to have to do a little dance with the effective date for those rules. Just to put that on the radar now. Page 27, line 1, means that you're moving into the section from Act 121 related to dams. There was a study committee on dam emergency operations, those things necessary for municipalities to plan for events related or occurring from dams. The report was due December 15, 2024. The agency is requesting to push that to December 15, 2025. On page 28, line 5, section 18. There was a requirement in Act 121 for ANR to do an analysis of the capital and ongoing operations of the Green River Dam. And you push that from January 15th, or this will push that from January 15, 2025 to September 1, 2025. And then you come to the last section, There was a provision in the Climate Superfund Act last year directing the agency to adopt the resilience implementation strategy by rule. Prior to the Climate Superfund Act, the agency was already working on the resilience implementation strategy, and they are nearing completion of it. And they had to go through a public participation process as directed by you in the bill to get there. They don't want to go through another process, rulemaking, before they issue the strategy. So they're requesting on page 29 that the requirement that the strategy be adopted by rule be struck. And instead on page 29 and 17 going into 30, that the secretary shall submit to you, the General Assembly, on or before September 15, 2025, the resilience implementation strategy, and it will include everything that you directed it to include in the Superfund Act on page 30, lines 1 through 5. Practices utilizing nature-based solutions intended to stabilize floodplains, riparian zones, shoreline, etc. Practices to adapt infrastructure to the impacts of climate change, practices needed to build out early warning mechanisms and support practices that support economic and environmental sustainability in the face of changing climate, and criteria and procedures for prioritizing climate change adaptation projects eligible to receive when implementing the students with cost recovery further. So
That's not a lot of time.
Right.
well, remember, they have already been working on it and they are already nearing completion of it. They would rather give it to you in September as a report rather than going through an 8 to 10 month rulemaking process. And they already have complied with public participation requirements that were built into previous.
Who are they gonna give it to in September?
It's right there on page 29. The House Committee on Environment and the Senate Committee on Natural Resources and Energy.
Special day?
And I have questions. We go back, on page 28, the Green River Dam thing. This was authorized in 2022. It was a 2022 act. I thought you said most of this was in last year's flood recovery.
This is the 2024 act.
Well, line 8. As authorized in 2022 acts and resolves.
Right, yeah, they don't believe they completed the analysis required in 2022.
Oh, sorry for that, laughter. So wait, we asked them to do it in 2022, they didn't get it done, so we asked them to do it again in 2024. And they didn't get it done, so now they're asking for a 9-month. Or 8.5 months. Cause they've already missed this deadline that's in here.
Right.
Well, I'll ask them, obviously this is on you, but I just wanted.
So the dynamic around this analysis is not free of politics. And I think asking them
Heard,
is better than me characterizing what's going on.
I look forward to asking them.
Very well, of course.
Page 31. Line 14, section 20, this is just a conforming amendment regarding the adoption of the resilience implementation strategy. You had an effective date in the climate, an implementation section in the Climate Superfund Act, which directed when these rules would need to be filed with ICAR and then finally adopted by LCAR. Since you're not going through rulemaking, you don't need that section anymore. There is another subsection that is related to rules required in Superfund Act that remains, and those will still go through rulemaking. And then section 21, effective date is passing.
I think I need that last part of section 20 one more time. I thought.
So,
This is about the climate super fund.
yeah, Climate Super
Okay.
Fund Act, the Climate Super Fund Act required the resilience strategy to be adopted by rule, you're striking that. But the Climate Super Fund Act also had an implementation section, which directed A&R when they had to start rulemaking. The previous chair loved that kind of thing. Wanted to know when they were starting, when they were gonna give an interim, when they were gonna finish. And so this is striking that provision about when they would have to initially file and when they would have to submit their final rules. Previous chair loved that for predictability and accountability.
Okay.
But it leads to things like that, you gotta get, when you change things, you have to do corresponding.
Well, we'll hear more about that. Thank you. There's a question here.
This one for
Yeah.
you,
Let's.
maybe, is there a possibility, because A&R is working on that plan, that we could get a kind of pre-brief maybe before the only second?
I think we could ask and see where they're at
Okay.
and if they have
Great.
a draft of any kind, I'm sure we could ask for that, though. I have my suspicions as to where they're at this point, so we'll see.
Can always get the gang back together in September.
We do
Okay.
a barbecue or something.
Any questions at this point? Still, okay, super, thank you so much. There's a lot in there, and we're just gonna go right down the list as we have it, so we're gonna welcome the Commissioner of DEC.
Thank you.
Hello,
Well,
good morning.
thank you for reading. I'll try not to be redundant here. It's always risky following.
Yes,
So
sir.
that gentleman. And we're looking for it. I would, so I'm Jason Batchel, the DEC Commissioner for the record. Thank you so much for having my staff and me here today to join you and go over H319, which is our housekeeping technical corrections bill. I've sort of been instructed by the secretary to break a little ice around that last question there and some of the deadlines that we're looking for and some of the rulemaking that has been essentially kicked down the road a little bit. And because of well, I'll just say we have asked for a lot, we have a lot in front of us. The charges before us are basically very plain. It rains a lot, and when it rains, our dam safety team has to show up. They usually have to spend the night. And that snowballs into a terrible ripple effect of backlogging. And those aren't answers that you like to hear, and they're not excuses. It's simply the truth. And if you'll back up to you may know this, you may not. When we looked at Act 121 and its implementation, we were looking at the charge before us, and you may hear this again today. We were looking at upwards of 21 positions. We settled on 17. We ended up with 15 with funding for 11. And so when you try to do the work with 11, the work with 15, and fund with the positions that are meant to staff only 11. And then you do the calculations of who has to do this work. It's not me that has to hire these folks. It's the experts that have to hire them, and they have to do the work that existed before the flooding. They have to do the work that existed before Act 121. They have to do the work that's in front of them now. It's a huge charge. And I think when those of you who haven't heard Ben speak and understanding his level of understanding and level of calm and level of expertise, you will have a greater appreciation for that today. And certainly you'll hear from him as long as you're here. He's a star witness, and he's our dam safety section chief for a reason. He does an outstanding job, as do all the folks that will be here speaking today. But not to make any excuses, but they've been kicked in the stomach quite a few times over the last 18, 20 months with summer floods, winter floods, spring floods. And they simply have to act when those things happen. I don't understand that, but I mean,
Sure, yes.
So the number of positions, the 1511 thing, I didn't quite understand.
Sure, and I think hopefully Rob's listening. When we initially were charged, I believe it was S213 last year that you all were working on here. When we looked at the body of work that was going to encompass, we said, I think that's around 21 FTE that it's going to take. When things really got started off, we said, well, maybe we could do this with 17. We ended up being blessed with 15, and then at the end of the session, we realized we only had been given funding for 11 of those positions.
In the budget, in the end,
In the-
you got,
exactly.
you got.
We got funding for 11 of those, and so hire 15, but you can have money to do that with 11. And so
So you still got authorized 15 positions, but you only got the money for 11.
exactly right.
I see, okay.
Exactly right. And so less with more, right? More with less. I always get that wrong. We are charged with doing more with less. And this sounds like a big, long excuse, and I apologize for that. And I will also offer that the secretary has asked to come in and speak just specifically on some of these timelines and from an agency perspective, which is hers, and I obviously share it. But I feel like she can say this very well if I haven't, and she would love to do that. But didn't mean to open with that. I understood that. I know you want answers, and everyone wants answers, and I'm sure the subsequent testimony you'll hear today is about making sure we put a wiggle on this, and we hear that and we
So just to
respect that.
interrupt you a little bit, so I'm planning on having secretary in to talk a little bit more about the rulemaking process, particularly around dams, and so we'll have more of an opportunity to chat about this. And I have one follow-up question though. You have money for 11. Are any of those positions vacant?
Yeah, so Ben can speak to this much more accurately, but my understanding is we're almost there. We're almost there with all the 11 that we, or excuse me, the 15 that we tried to hire. Am I wrong about that?
We were given authorization for 4, we've been able to build 2.
Okay. That would be your double
Working
working
on
hire.
like
Yeah.
additional 2.
So there's a hope that more folks may be hired even with the money that you do have. Great.
And I should clarify, Senator, that those 15 positions span the entirety of the DVC. They aren't all in safety, some are in rivers, and the work is shared, and you'll hear about some of that.
It
Okay.
was for the full Flood Safety Act or body of work, not just the dam part of it.
Yes, ma'am.
Yeah, got it, okay.
So I'll just give my intro and I'll turn it over to the experts. So again, I'm Jason Batchelder, I'm the DEC Commissioner. Thank you so much for having us, Environmental Conservation. And thank you for taking up H319 as it came over from the House. The department does support this bill. And I think you'll see the reasons why, and getting this work done is the big ask here. And so pushing those deadlines is important to us as much as it pains us. I'm joined today by Waste Management Prevention Director Matt Chapman, who's gonna speak about some of the extended producer responsibility and other things that Mr. O'Grady touched on. Rob Evans, River Scientist and Program Manager with Watershed Management Division, talking about Flood Safety Act in general and a little bit more granular. And Dam Safety Section Chief Ben Green, and also Director of Policy and Planning with Secretary's Office, Billy Coster, who's going to speak to their respective sections. In the interest of time, I understand we only have an hour. I'll probably just simply get out of the way at this point. I didn't want to say those pieces, but I think you'll learn more about the folks in front of you from them. Their sections are very well broken out, and I think you'll learn a lot today. I'm happy to take any department level questions with like Art, but I think you'll appreciate that when you're looking.
And I think the key is to know that you all support this bill, so it's helpful. Thank you.
Yes, Madam Chair, and thank you so much for having us.
Absolutely. Great. All right, so we'll move on to Mr. Chapman. Welcome.
Good morning.
Good morning.
So for the record, Matt Chapman, I'm the Director of Waste Management and Prevention Division within the Department of Environmental Conservation. On the website today, I have a slide deck that I put together, just like in the interest of time. I think I'm not gonna put it up on the screen, but it's available for folks, to sort of both walk through and for reference going after the discussion. And so I'm going to sort of start with the start and middle that are sort of my sections. The first one is, and I'm going to probably speak more to the why than to the what. I think Mike did a great job sort of going over the substance of the proposals. So with respect to the battery study and the extension of time, part of the reason we're asking for this change is that we discovered after the bill had passed that the states of Illinois and Washington are doing an identical study to the one that we're doing in the state of Vermont. So rather than us contracting and spending state money, we were going to work with the stewardship organization to coordinate a broader report and have it come in. So it's just frankly an efficient, good sort of thing to do. With respect to section 2, which is the delivery prohibition or red tag authority. So this again is sort of like sort of to clarify a little bit. So we've always had this authority. Basically, when someone is in violation of right now an enumerated set of statutory violations, we can prohibit delivery to an underground storage tank, a gas station. This makes a slight change to that authority. We have not historically had the ability to prohibit delivery to people who don't have a permit. We now have that authority, or this is proposing to add that authority. The other is that all of the violations are geared towards but aren't precisely associated with violations that relate to a release of gasoline from that tank. And again, the main reason for red tagging or prohibiting fuel delivery is you're not doing the things you need to do to keep your tank up to date to prevent releases. The state actually pays through the gas tax from the petroleum cleanup fund for those. So this is a conservation of state resources as well. Now the sort of like the larger portion of this, so sections 3 through 9 cover the changes to the household hazardous waste extended producer responsibility law. And I think it's probably good, since most of the members, or at least 3 of the members, don't have some context, just to provide a brief bit of context around where the underlying law came from. As many of you may know, our solid waste districts and municipalities in the state have either HHW collection events or permanent facilities to collect HHW. There have been escalating prices in how much those events cost, right? Going from the setting up of and contracting with a contractor itself, also for the cost of disposal, but it's predominantly been from the contractor costs, not the disposal costs. The districts raised this as being a critical thing to have happen, and the legislature passed it 2 years ago. And over the past few years, the agency has been working with, and I should again just take one step back. Household hazardous waste is waste that's generated by a household that is just as toxic as the waste that's generated by a business, but it's exempt from our regulatory structure under the hazardous waste rules because it's generated by a household. And it's basically a lot of cleaning products, lubricants, nicotine vapes. There's just sort of a wide cross section of products that fall into the category of household hazardous waste. And that's frankly where part of the problem started happening when we started implementing this. There's a lot of different manufacturing sectors that don't normally work with each other. They don't have relationships with each other. Unlike the battery companies who all sort of at least know who to reach out to and contact, there wasn't sort of a natural relationship that existed between these manufacturers, which is why it has taken more time and why we are recommending some of the changes, basically to provide greater incentives to manufacture, some clear points to manufacturers to come into the system, register with the system, and take part in the system. And so that means manufacturers, there's a new requirement that they're gonna have to register with the stewardship organization, and that's a requirement. If they don't do it, it's enforceable by the agency. Also, it sets up the ability for the agency to basically run its own stewardship organization, which, to be clear, is not something that we want to do, but we think that it's important for there to be a backstop in case they fail to meet their obligations. So I'm gonna stop there. I think Mike did an incredibly good job of just sort of walking through the details and just pause and ask whether there's any questions, and knowing that we have a lot of people in limited time. If not, I'm more than happy to come back and make myself available.
If I have any questions at this point, I'm feeling pretty clear about it, I think. I'm really grateful for your work to get to this point, to see what was necessary to be moving forward in a logical way.
And I should probably say that we spent a fair amount of time working with districts, manufacturers on the changes that are here before you. I will not say there's complete consensus on everything, but there's a broad array of agreement what we put forward.
And the broad array of agreement, that's with manufacturers or?
I think it's fair to say that, and they obviously can speak for themselves, that we worked with the districts and the manufacturers on the changes that you see before you in this bill. Now, there are other conversations around this taking place around, say, for example, whether the paint program should handle paint, and whether, how that goes. And that is not a part of the bill at the moment. I know those conversations are taking place. There may be some sort of further amendment that folks come in and ask you to take a look at, but that's not in what we're talking about today.
So we can let that play out. A couple questions here. Go ahead.
Okay, I'm looking at your slides, which
Yes.
are really helpful.
Great.
The slide, what the law does, it says A contains stop sale. What does that mean?
So it basically is a provision that if you don't do what you're supposed to do, if you're a manufacturer of HHW and you fail to register or you fail to participate in the program, the ultimate end enforcement option that we have is to tell you can no longer sell your product in the state of Vermont.
Got it, okay.
And that's pretty common in EPR programs. If you don't participate in the program, then you can't sell your products in the state.
Okay, that makes sense. I'm sorry, I had to go to down the hall.
Okay, no worries.
Thank you, Matt.
Good, thank you. Senator Beckett, do you have a question?
I don't.
Okay,
Great, thank you.
thank you. All right, super. Okay, so we have Mr. Evans with us on the screen. Welcome.
Good morning, Chair Watson and committee. I guess first things first, can you hear me okay? Tech check.
Can you turn it up just a little bit? We can hear you. Can you say a little bit more?
Sure, test.
That's good. I wonder if we could do even just like a little bit more. Is that okay? Does that sound about right to you?
Keeps bouncing.
Okay, go ahead. I think we're probably in a good spot.
Okay, I'll use my loud voice if that works. For the record, I'm Rob Evans. I manage the Rivers program in the A&R Department of Environmental Conservation. Thank you for the invitation to speak today on 319. Regarding the proposed date extensions for our work implementing the Flood Safety Act, I only have some brief introductory comments, and then I'm happy to take your questions. To recap, the Flood Safety Act requires really important work by the Rivers program with the goal of making Vermont more flood resilient to flooding. As Council O'Grady reminded us, the Act requires mapping, education outreach, multiple rulemaking efforts, a study committee work, along with multiple legislative reports. During the 2024 session, in both this committee and House Environment, we expressed concerns with the timeframes to accomplish the work. Specifically, we articulated that we would need 5 to 6 years to get all the work done, as opposed to the 3.5 years that was provided in the law. Needing more time was due primarily to the following. The first is the time lag associated with hiring and training new staff and getting consultants on board to help us accomplish the work. We indicated we'd likely need 18 months before the work in earnest could begin. We were provided in our program 5 new positions to accomplish the work. Recruitment efforts are underway, and we hope to have most of the positions provided to us filled within the next month or two. This is on top of 3 existing vacancies we had, so it's been a sprint of sorts to try to fill positions. Once we have everyone on board, then we shift to training, and then we will also pivot to getting contracts developed and executed, because we're provided generous contractual funding to get consultants on board to help us with the work. And that's likely going to take us to the remainder of the calendar year to get contracts executed. We also described last year, this will be no surprise to anybody, and Commissioner Batchelder touched on this, we have a huge volume of flood recovery work, as we described last year regarding the 2023 floods. Flood recovery technical assistance to support mitigation project development, largely funded through Vermont Emergency Management, goes on for years after a big disaster. And our program has a significant role in that work. And lastly, in related fashion, we expressed concern that any additional flood disasters would set us back further. And as we all know, we had 3 more significant flood events last summer. And so when you roll up the floods of 23 and 24, we received 6 federal flood declarations over a 14-month period. So here we are. Bottom line is we need more time. And I'll stop there and answer any questions you may have.
I don't know that I have any questions. So you had 6 flood declarations basically in, did you say 18 months?
14 months.
14 months?
Yeah, basically June of 23 to August of 24. And those were all summer events. But yeah, 6 federal flood declarations.
Yeah, that is a lot.
It's tremendous.
And so, just in terms of your recruitment efforts, now you said you're hoping to have these filled to be fully staffed in the next month, or
next month or two. Some of the folks we're offering positions to are moving from out of state, and of course, finding housing takes time. So we're having to give them a little bit of time and space to secure housing to move to Vermont.
Yes, absolutely. Great. Any other questions from the committee? No. Super. I am. Do you have any comments about this question about like having a year and 2 weeks?
Actually, you read my mind. I was going to comment on that. That was a mistake. So
Okay.
if you want to move, Council O'Grady, if you want to move back that to July 1 and not 15th, I'm perfectly fine with that.
I don't think we need to. It's just, it was a curiosity. So
yeah, curious to me as well. Thanks for pointing it out.
Yeah, no problem. Great. Any other questions? Okay. Let me look through this, make sure there's nothing else.
Happy to come back and talk about any of the elements in more detail if you would like.
Okay, great. Thank you so much. Really appreciate it.
Thank you. Take care.
For sure. All right, and Mr. Green, come on up. Welcome.
Thank you.
Yeah.
I do have just 2 slides there. I'll get through.
Sure. And actually, while you're setting up, I do have a question for Commissioner.
Yes, ma'am.
I'm just in the order, we've been kind of flipping through the pages as we've been talking about the issues. One of the things that came up as a question was, I'm not gonna be able to find it here in this moment, but there's a piece about the confidentiality for those participating in the Healthy Homes Initiative with mobile home parks. I don't know if you have an answer to this right now, but just to put it on the radar, here it is. So it's page 21. Wondering if you all have the ability to analyze the data in aggregate, or because of the language of like all information submitted, etc., that prevents data from either coming out or being analyzed in aggregate. Does that make sense?
I believe it or not, I wrote that down when Senator Hardy posed it. I'll take it back to the group. My off the cuff answers, I cannot imagine that data will not be harvested and for for our own knowledge and you may know this, but our general counsel at all levels is very pro Public Records Act.
Yeah.
If this stuff is able to be turned over, we will turn it over. We aren't going to erase it, and we aren't going to alter it, obviously, and so. And perhaps, I see Matt perking up, maybe he can give a little here, but I can't imagine this information will not be available, and I don't mean to put you on the spot.
No, that's okay. So, in the interim, I emailed Marjorie Clark, who's the director of our enforcement division, and she said yes. That basically there'd be population levels or program performance data that would be available to the public, but it's trying to get rid of sort of personally identifying information and because of the sort of challenge both with accessing the program and for having your personal identifying information out there.
Okay, thank you, that's helpful. I mean, I may just want to also just like check with our legislative council to make sure this phrase, all information somehow doesn't conflict with that. I think it's worth just checking, but thank you. So it's good to know that you don't think it's a problem.
Sure, we've been in the office, we call it personally identifiable information, and so we don't mean to exclude, just as by our own vernacular, that we have no intention of excluding stuff that's not personally identifiable.
Okay.
I'm happy to help that along.
Great, super, thank you, that's great. Okay, I'll shift to you, welcome.
Thank you. For the record, my name is Ben Green. I'm the section chief of the dam safety program at the Vermont Department of Environmental Conservation Dam Safety Program, and just going to touch on the two elements in H319 that touch on dates for projects or initiatives that we're involved in, which is the emergency operations planning for dam study committee and the Green River Reservoir Dam and Dike study. So just a little bit of background that in Vermont, there is no county level government or county level coordinated emergency management services. Per statute, local emergencies, including flooding, are the responsibility of local town emergency management director and instant commander with some support from state. For some larger, perhaps more well-funded communities, this is workable, but for many small rural communities where dams are located, this is a hardship. Another issue we have here in Vermont is few dams have what we call a viable emergency operations plan due to limited capabilities, funding, and staffing at some of the small localities. To work on this issue, the legislature set up this committee to help identify current practices and find ways for improvement and potential solutions. So the status of this committee is the first committee meeting occurred in November 2024. With the members listed here, we've also had quite a bit of participation from other dam owners, RPCs, Representative Mahali and others. To date, 5 of our scheduled 8 meetings have been held. We looked at topics, dam emergency action plans, operation planning, local plans, and also looked at some success stories in Vermont to see how we could kind of carry that to a larger scale. At this point, the draft outline for the report has been developed, as well as some of the standards that we'd like to include in that report. We're going to be reviewing those with the committee at the next meeting, which is scheduled for 4/7. So following that, we have 2 additional meetings to complete the report and are on target to complete this project, frankly, before December 15th. So that's the status of that. And then the Green River Reservoir Dam and Dike study, just a little bit of context on that. Green River Reservoir Dam and Dike, owned by Morrisville Water and Light. It's a federal energy regulatory commission regulated dam because it produces or assists to production of hydropower. It's a concrete arch dam, 360 feet long, 100 feet tall, making it the tallest concrete dam in the state of Vermont. Due to environmental regulations imposed on Morrisville Water and Light during the most recent FERC licensing, Morrisville Water and Light concluded the site was no longer economically viable to operate as a hydropower facility. And keep in mind, the area is surrounded by a state park and is the longest undeveloped shoreline in the state of Vermont. Legislature directed the A&R to study the possibility of the state taking ownership, a job that was delegated to the dam safety program to oversee and manage. The work was being completed by GEI consultants in partnership with us and Morrisville Water and Light. The project was being completed in 2 phases, and I can go into a lot of detail why that was, but if you'd like to know, but the general scope is listed out here: completed tasks checked off and upcoming tasks dated. And we have a great amount of momentum. Essentially, the fieldwork got completed last construction or last field season. Over this winter, structural analyses and H&H analyses have been completed, or actually due. The final report to due later this week. There's a dam valuation aspect to the study where we're evaluating the value of the dam, the value of the hydropower, and the value of the recreation to help decision makers have a full picture of the situation. There's also a risk assessment for the dam. It's going to include a workshop between our consultant, dam safety program, and Morrisville Water and Light, with the workshop scheduled in early April. The consultant's working on capital and maintenance cost estimating and future ownership. That's something that's ongoing. And then we have a workshop in the end of April to look at different alternatives for the contract with Morrisville Water and Light and our consultant. As if the state were to take this on, what could it possibly look like? What are the pros and cons? What are the costs? So that can be documented in the final report. The contract with GEI is through July, so we anticipate being done in July. So it will be barring any flood. I see no issues in meeting the September 1st, 2025 deadline. So we have a lot of momentum. Hopefully this will be completed soon.
It's great. And so all of those, for example, like the workshops, like those are scheduled, those are, they're on the books,
Yes.
they're happening. So, great.
Yeah.
So it's rolling.
Yeah,
Awesome.
we have the momentum we need, we have the funding we need, we're moving ahead. That's
Great.
the pace now.
And just so I'm clear, this is a study to see about the potential for the state to.
Right, it's like the legislature to have the debate about whether it makes sense for the state to purchase and take this over
Yeah,
and to understand the pros and cons of doing so.
good. And this is the study, the analysis that is referenced in section 18. Or no?
In 319,
Yeah,
yes, yep,
yeah, great. About the Green River Games.
yes, yeah, this is the study.
Great, super. Any questions? No? Okay, super, thank you.
Thank you.
Great, any other questions about particularly the dam section? Oh, yes, go ahead.
Any chance we could get it added to an invitation list for these workshops?
Potentially for the alternative analysis workshop, one challenge that we've had throughout this entire project is that the dam is Federal Energy Regulatory Commission regulated, which means that a lot of the data that supports the plans and specifications and information about the dam is called critical energy infrastructure information. So to have access to that information requires signing a non-disclosure agreement,
Oh,
and it had made Morrisville Water Line's been a great partner about this entire project, however, it has made challenging sharing information and those kinds of things, and also the final report there'll be essentially two final reports, one that has all of the information that is EII compliant that will only be shared with people that are have the certification to look at that, and then there'll be a version that's publicly accessible that doesn't share some of that critical information. So that's one challenge that we have, but so I believe the risk assessment one probably is not,
Yep,
and then
okay,
the alternative one potentially.
Just so that I am clear, in section, so because I think I'm clear on section 18 about the Green River Dam study, that's good, and then in section 17, there's a different study.
Emergency operations,
Yes.
yes,
Oh, was that the first one you were?
yes,
That was the first one you were, about the emergency action.
maybe, yep.
Yeah, okay, that makes sense. And then, from the Flood Safety Act from last year. You all were going to be getting, how many new positions? Was it 4 new
Yeah.
positions?
4 new positions, we programmed it as a project manager, a technician, and then 2 engineers.
Okay,
We've managed to fill and have in-house now working project manager and technician, and we're trying to recruit the engineer position for about 125 days, and we're continuing to try, and this unfortunately not had qualified candidates available yet, but we're continuing to try.
great. So, so is it just the one position that you've yet to fill, or the two?
Two middle engineering positions are the ones that are still unfilled.
So hopefully we can find a couple qualified folks for those positions.
Yeah, for in connect with local universities, Illinois universities, yeah, we've grant organization, et cetera, we really try.
Great, super, awesome, thank you. Great, and let's see, so. Thank you, everybody. Any other questions for the set of folks that we have spoken to so far?
I'm not
Oh.
on your agenda, but I'm happy to talk.
Oh, yes, would you like to talk? Go for it, yes.
Good morning.
Good morning.
For the record, I'm Billy Coster. I'm the Director of Planning and Policy for A&R, and I'm here to speak in support of section 19 of H 319, which is relevant to the Climate Super Fund and the Resilience Implementation Strategy rulemaking. As Council O'Grady explained, what this seeks to do is remove the requirement of the Resilience Implementation Strategy go through rulemaking, and that we simply adopt it as a strategy and then present it to the legislature in its complete form. All of the performance standards, public engagement requirements, all the prescriptive expectations the legislature had put on the board are retained. It's just really that rulemaking provision. As Mr. O'Grady said, we are well along in our process of developing this. We expect to have it done on July 1st. We just had a large stakeholder event all day on Monday of this week. And folks from our climate action office have been providing updates to House committees on this project. So if you all were interested, they're certainly at a state where they can provide a lot of information. And I think from our perspective, we really see value in the rulemaking process. It confers the power of law on the rules and programs we implement, and it really has its place. We see this strategy as a more dynamic implementation plan that by its very nature is going to change as conditions change, as new programs become available, as new funding becomes available. We really want to have this be a living, breathing document. Rulemaking has a certain level of rigidity that isn't consistent with that dynamic nature. You know, to make substantive changes, we have to come back and go through the rulemaking process each time we want to make those changes. And we just don't really see the need or value of rulemaking to be conferred on this strategy. So that's really it. It's just taking something that doesn't fit particularly well as a rule, changing it as a report, and then trying to implement it. I will say this was a recommendation. The first requirement of the Climate Superfund Act was that our agency and the treasurer provide a feasibility report to the legislature. We did so in January of this year. It had a number of recommendations, one of which was to make this change. The others were primarily focused on additional staffing and contract resources that both the treasurer's office and our agency believe is necessary to do the work on the prescribed timelines. We were trying to achieve those outcomes in the House through the Fair Appropriations Committee. It doesn't look like they're going to be able to fund those positions and contract capacity. So that may be a conversation we'll have to take up in this.
Thank you for flagging that. I think that's something that we might want to take some more testimony on and see what may need to be done to make that progress realistic. So
Great. We can certainly, in partnership with the treasurer, do a deeper dive into this.
okay, super.
Thank you.
Thank you so much. And I think that was section 20. I think you might have said 19, but I think
You are right.
just wanted to make sure that I am. Oh, maybe I'm wrong.
My version says 19
So let's see. Oh,
and 20. It's
19 and 20.
Yeah.
Okay, yep. I
20 basically takes the deadline, but.
think I have not processed that 19 is about that too. Great. Perfect. Thank you so much. Okay. Great. We are at 10:15.
I have to, because she's.
Oh, do you need to leave?
I have to leave by 10:30.
Okay, well, let's.
Time is till that.
That's
gonna break.
no, that's okay. Are you all okay for another, 10, 15? So I assume it's, yeah, okay, great. And then we'll probably take a very short break, at 10:30, and continue on from there. Great, welcome.
Thank you. For the record, I'm Karina Daly, restoration ecologist with Vermont Natural Resources Council. And I'm here to just follow up on our conversation of 319 and some of the timeline pushback requests. And fully appreciate the agency's testimony and support that they support this work. And I guess I just wanted to dive a little bit deeper into some of those timelines and recognize the fact that all of this rain and these flooding events certainly has kept the rivers program and the dams program and really the water resources program at the agency super busy. And that also should elevate the need to move this work forward ever faster, and it's very significant that we move it forward. So I just want to make sure we're looking very clearly at those pushbacks in each area, and I think overall, I didn't have so much concern with the wetlands or the dam timelines. We worked really hard. I think the wetlands, if you look in the wetlands section of 319, they're really not pushing them back more than 5 or 6 months in both cases. And I think a lot of the dam work is continuing, so that really there's only those two, the study committee and the Green River Reservoir study that are being pushed back. So I don't have concerns so much with that. It's more the domino effect of the river corridor, mapping, education and outreach and rulemaking that is really significant, and I understand the capacity frustration there. But it does really create a domino effect of once one is pushed back, then the other. And I just wasn't sure, so specifically, I'm looking at the mapped river corridor rules, going from July 1st, 2027 to July 15th, 2028. That pushing that rulemaking, making back a whole year and 2 weeks is significant. And then the permitting requirement that follows that, which is line 15 of page 24, going from January 1st, 2028 to July 1st, 2029. So I guess I was hoping that there would be potentially some conversation about why are we pushing that back a year and a half more versus just versus a year, 6 months. So and it is a domino effect, you know, if you push the education and outreach and the mapping back, then you have to push these back, but hoping that there's opportunities to tighten that up a bit, because I really just feel uncomfortable delaying as these storms keep coming. And I think with that, I'll put back on to say if there are questions.
Any questions? Yes,
So you have a recommended date?
I would recommend that we change that permitting requirement date from January 1st, 2028, January 1st, 2029, but I would want to confer with the agency further on that. I'm not sure if Rob is still available. I just wasn't sure if that was something that he had recognized that for a typo on the 15th versus the 1st on the earlier one, so I wasn't sure if that was the case with that one as well.
yes, good.
Can't help noting the irony that one of the reasons for delaying is all the floods we're having, and this is about.
Exactly.
There was an irony there, and an intention, actually, built intention to what we're trying to accomplish. So yeah, speaking for myself, it'd be great if you had that conversation.
Yes, I'll follow up with that.
Because it is true that every even months we can gain is better than not.
Right.
So this is we do this again and again.
Exactly.
There's something about thinking about that first one that was a year or 2 weeks, like just making it before July 11th. Symbolic.
Workshop.
Thank you. Yeah, I don't know that we have Mr. Evans still on the line with us, otherwise, you know, that's something we get discussed right now, because that would be interesting to know, like, what it, you know, is a year and a half on purpose, and what's the thinking around that length of time. Yeah, so we can follow up on that.
Yes, and I will as well. The other one I noticed that I had a question about as well, and I can follow up on this, is section 14, which is under the flood insurance program, but I noticed that the rulemaking is initiated July 1st of 2025, but then the rule isn't, shall be adopted until July 1st, 2028, so it's a 3-year. Am I reading that correctly, that it's 3-year? Section 14, line 16.
Yes, there's a 3-year. Yeah,
And that's something that seems like a very long gap.
Can I just offer?
Oh, yes, please.
Behalf that,
Sure.
you know, that is gonna create a regulatory program that affects over 5,600 river miles. And I forget what we estimated, but tens of thousands of property owners, so I do think that, while 3 years may be overly generous. Having sufficient time to engage with Vermonters about that change is gonna be important.
Great, thank you.
Right.
All right, thank you.
Thank you.
Okay, great. Well, I think we're in good shape in terms of timing here, so let's take a break until 10:30 and then Okay, this is Senate Natural Resources and Energy coming back from break. And we are again coming back to through the H319 or a bill related to miscellaneous A&R subjects. And so we're gonna be jumping back into the solid waste issues. And so we have Karen Lace-Leeper with us from the Central Vermont Solid Waste Management District. Welcome.
Can I jump in with a quick?
Yes,
question?
sure, yes.
Unrelated, I think, but
Okay,
this little, very seconds and then,
yes,
I know, I looked and saw where it goes.
yes.
Did that happen already from the House floor, or is this a separate bill that would
Coming over. I think.
Okay. to ask us to ask?
Possibly, yeah. We can't
Okay,
clarify what they're
Okay.
asking us, but it's coming home.
okay,
Yeah. I think we'll know more once we actually have possession.
Got it.
Yeah, and then it'll
Okay.
either be there or. won't be,
Okay.
so.
Nigel said it's coming over to the Senate.
Okay, very good.
He's the clerk and.
Welcome. I think we should do a quick round of introductions. Hopefully we'll have Senator Hardy here with us shortly.
Senator Terry Williams, Rutland District.
That's me.
In Washington District. Hello again.
Seth Wallace in Bennington District. Scott Economy.
Nice to meet you all.
And you've met our committee assistant.
Yes.
Great, okay.
Thanks for having us. I'm here, I'm the general manager for the Central Vermont Solid Waste District. We're here in Montpelier. And I'm here on behalf of the Solid Waste District Managers Association. We represent all of the solid waste management entities around the state charged with implementing the materials management plan that the Agency of Natural Resources, DEC Solid Waste Program puts together every 5 years. That includes the management of household hazardous waste, and the provision of those services, either through seasonal collections or permanent facilities. So we're here in support of the amendments to the Act 58 through H319. Primarily want to talk about the household hazardous waste EPR extensions. So we are in support of these revisions. Pushing the deadline out a year is unfortunate. I think from our perspective, it's indicative that the producers of these materials are dragging their feet and not providing the requested program plan for managing these materials. But in the interest of having a good program, pushing that deadline back and pushing back the associated landfill ban for household hazardous products does make sense so that we can make sure that gets established in the way it works. As it is currently, the solid waste districts are responsible for paying for the disposal and the management of these materials. And as Matt mentioned in his testimony, those costs have continued to increase, both in disposal and in staffing and contractor fees. So this legislation is really important to helping us municipalities, provide these services in a financially sustainable way. So any questions before I go on any of that?
Yeah, I'm just wondering, do you have a sense of the scale of how much these household hazardous waste collection days are costing you?
Yes, so currently just for disposal, we're not talking about staffing, contractor fees, et cetera. It's about $100,000 for our district a year, just for the disposal fees. That's gone up significantly in the past few years, and yeah, this legislation should help with funding it. It's modeled after many other existing extended producer responsibility legislations for batteries and mercury containing devices and universal waste, the electronic waste, right? All of those are really effective programs and do a great job of reducing the toxicity of the waste stream,
recapturing recyclable or salvageable materials and keeping those out of the landfill, which as we know is limited. The household hazardous waste is really focused on the toxicity of that waste stream, and making sure that those materials are disposed of safely and in an environmentally responsible way.
And you're supportive of I'm just thinking about the issues of getting all these manufacturers together as a part of a group, and I was appreciating the language of having the backstop of the agency forming an EPR if or the stewardship organization if they don't do it themselves, and so you're supportive of that backstop.
Definitely. Yeah, as you know, as we've seen, they've had at least a year to begin putting this plan together, and have not. So I think it's important to have A&R have the ability to put that plan together for them and charge them for it, as well as to prohibit the sale of non-participatory organizations.
So if that maybe this is also a question for Mr. Chapman too, but if that backstop were somehow necessary, it would ultimately be paid for by the manufacturers. Because that would be an administrative burden, of course.
Yeah, so the agency would put that plan together, they would charge the manufacturers for administering it. And then ideally, the districts, the solid waste entities would receive some funding from the state for the management of those materials all through that program. Another just couple of things I want to mention on this. There were initially some exemptions written into the House version of this bill for other household hazardous products. And we wanted to make sure that that we called that out and asked that you not consider exemptions for household hazardous products to this bill. It's pretty straightforward as it is. It just pushes the deadline out and gives A&R the agency to create that plan and charge producers for it. We don't want to see any exemptions for hazardous products. As far as our operations go, that adds cost, time, complexity of managing the materials. And so that's our position on it.
Yeah, that's helpful. Any other questions?
Thank you, Madam Chair. I'm sorry I missed a bunch of the conversation this morning, but the charging the manufacturers, but you have the bill, page 19.
Yes.
Is this, I think it's lines 7 through 12. Is this what you mean, the charge that would happen? It's 10% of the plan's total cost?
Yeah, I would even say that percentage could go up, but.
Yeah, I was gonna say that seems pretty low.
Yeah.
Because essentially the agency is incurring the costs and then they're only charging 50% to this.
So they would be charging the cost of administration plus 10%.
Or plus 10%.
I'm saying.
Is that,
That's correct. Yes.
okay,
Which is why it's a carrot for them to do it themselves.
right, okay, that makes more sense to me. I was like, wait, that's not.
Why would they?
Why would they
10%?
10% source market?
I want 90% off.
Okay, all right, thank you.
And in anticipation of this coming into effect, we're in the process of getting our own permanent facility set up in central Vermont, which is an identified gap for household hazardous waste currently.
Any other questions? Yes, go ahead.
Maybe I could touch, Michael, I think you picked that up for a reason. I mean, maybe you ought to say line 8. After the reduction, additional assessment or something.
Yeah, that might be helpful because it wasn't clear to me.
Yes, I was thinking the same thing, actually, like as it was explained, you know, I want to make sure that as it's explained. Matches the language.
And how much does one of these plans cost?
To put together,
Yeah, so what would 10% be like? Maybe this is for Matt.
Do you want me to go ahead? Yeah, so I mean, I think that, you know, we did some really rough estimation for a fiscal note in the house. And I think that, so it's not just the putting together the plan, but it's also the administering sort of the program, compensating the solid waste district for the programs that they run. You know, running an outreach and education program, sort of all the elements that are included in the plan. You know, an estimate that we gave was somewhere between $5 and $8 million. roughly speaking, when you spread it across the entirety of this.
So this would be 10% of $5 to $8 million.
That's correct. So it would basically be the total program, what it anticipates is that we would send bills to manufacturers of HHW based on their national market sale, prorated back to Vermont
Right,
for the total cost of the program, plus an additional 10% to be used for pollution prevention and HHW.
okay, so it could be like 5.5 million and 0.5 million would be the extra 10%.
Oh,
Correct.
5,000 that we get put in.
as I'm reading this now, because it's a list. The secretary shall charge each manufacturer the prorated cost of the administration plan,
Mhm.
the agency's oversight costs, and the hazardous waste reduction assessment of 10%. So maybe it works, but
Yeah, you're right,
Yeah.
read the whole sentence.
right, but
Yeah.
it sounds like the intention is it's gonna be charging each of these things.
That is correct, yes.
Okay. Yes, go ahead.
Just a quick question, so solid waste district or municipality?
That's correct.
Okay, so eventually it sounds like this could end up being revenue for the solid waste district. They're all gonna be those.
That would be great, yeah, currently, you know, all of our programs and services are funded through our different revenue sources, which is, you know, per capita assessments, surcharge on solid waste. Other districts have different funding sources, but those are the primary ones for us.
And for government link, the municipality fall under A&R for oversight or?
That's who we report to.
Yeah, I mean, I think we have sort of a planning oversight function with the solid waste districts, and we certainly participate with them. When there are, like, they'll come in, like a district will come in for a municipal charter change, we'll often sort of monitor that and comment and work on it, yes.
It's interesting thinking about solid waste management districts as having charters. It's curious.
Can they participate in the SALT program?
I don't know. Spread salt. Okay.
So this would ultimately, and I wasn't on the committee last year when they created this, but. This should ultimately save consumers money because we would no longer have to pay you guys to take our household hazardous waste.
That's the goal.
The project, the manufacturers would pay for it.
Except that the manufacturers are gonna pass that down to the consumer.
Except that they are giant and it would be
I know,
like
but yeah.
1/10 of 1%, 1 penny or something that would go.
So small.
Had this discussion. but-
Yeah, I figured we did, yeah.
What's happening, it's not worth it.
Yeah, it's just not worth it, yeah.
Yeah, it's not cost effective for them to make the change.
But it often costs us money to go take something to our solid waste district.
What's the distribute, well, this is. You know, channeling testimony from last year, but the distribution areas don't match up with. State boundaries and. Great, any other questions? All right, super, thank you so much.
Thank you for your time. If you have any other questions, feel free to follow up with me or Jess or Jen from Chittenden Office.
Super, great. All right, super, and so now we're gonna welcome Ms. Holiday. From the Chittenden Solid Waste District.
Thank you, Madam. Hello, everyone.
Should we do a quick round of introduction?
Well, I was sitting there, so I.
Oh, you heard, of course.
Yeah, so thank you, though. For the record, I'm Jen Holiday with the Chittenden Solid Waste District. I'm the Director of Public Safety and Communication. I've been there for over 30 years. And working on extended producer responsibility legislation for almost 20. Household hazardous waste has been the one that we've worked on, the SWIMMYs. I'm gonna call them SWIMMYs. I don't know if you're familiar with that acronym, it's solid waste management entities. To make it short for SWIMMYs. So there's some solid waste districts that are municipalities. there's some solid waste districts that don't have that authority, the towns that formed it, they're not districts, they're alliances. The towns that form the alliances don't give them that authorization. So we're all a little bit different. So for SWIMMYs, we've been working on household hazardous waste extended producer responsibility for, since 2016. Just to give you an idea of how important it is to the SWIMMYs. 2017, the first bill was introduced, and there's been 6 bills in total, with 2023, the one that finally passed age 67. And the reason why it's so important for us is because it is the most toxic, it is the most difficult material to keep out of the waste stream, and the most expensive. So it does cost millions of dollars every year to do this. It's very difficult. So it's really a prime candidate for extended producer responsibility. CSWD supports these changes in the bill. We are leaders in EPR in the United States. We passed some of the first laws on products, primary batteries. We have some of the highest collection rates per capita on all of our EPR programs. And HHW was the first EPR law. EPR law heritage, it was the first in the country as well. So we did expect that it would be hard to figure out. And it's not a real surprise that the producers had a hard time organizing and getting it together. But I think with the provision that's in the bill, the ANR can write the plan and implement the program. If they fail to do so, is really assurance that we're going to have a program ultimately in the next year and a half, which is important for us. But mostly what's important is that we have a good program. And I think without this delay, it's not going to happen. So that is why we do support this. I just want to make it a point to bring to your attention in this bill and in the original bill, there is the requirement for the plan and the program to make municipalities and SWIMMYs whole in their costs associated with managing the household hazardous waste. That is somewhat of a new provision since some of the past laws that have been passed. And the reason being is that it's a real fundamental, basic foundation of extended producer responsibility, in that the costs are covered by the producers that produce this material. And some of the previous programs upon implementation, all of the costs have not been covered. I'll bring paint up as an example since we were talking about that. Mostly the paint program, which is an excellent EPR program and runs really well. That material, the SWIMMYs are not covered for much of their labor, or any collection event fees, which are considerably high. And so we wanted assurance that the language is very clear that labor, facility costs, fees associated with collection from contractors are covered. To Darren's point about exemptions of different materials, there was a request from the paint industry to make exemptions for some of the paint related products, such as paint thinner, in this law in the House bill. We opposed that language because a significant portion of what is in this bill is paint related products. And if it goes over to the paint program, the SWIMMYs will not be covered fully for their expenses. So I just want you to be aware of that.
Jen, if I can add in that, the paint care program is also funded through a consumer facing fee, so on purchase. Vermonters pay an additional fee to fund that program. And in the interest of watching out for our constituents, we're also hoping that, everything else that's in the hazardous waste program will be funded by producers instead of Vermonters.
I'm also just an extension. All right, sorry, please, okay, go ahead.
So that is, mostly what I have in terms of, we support this bill. I have, a comment and then, a couple of things that we might like to see added to this. There are performance goals in every extended producer responsibility law. Performance goals are, you have to collect so much percentage of what you produce, something that holds the program to a higher standard to make sure it's effective. And the performance goal in this law is that 5% of households will participate statewide in the program. Currently, Vermont has more than 5% of the households participating statewide. So I would say that bar is a little too low. And I would like to see that raised to at least the level that we have today.
What page are you on?
So that is page 1695. And I haven't looked at this data for 2 years, so I don't know exactly what the performance is today for collection. But I would like to talk to A&R and come up with a different number than that 5%.
Is that something that you're hoping to do before the ultimate passage of this out of this session?
Yeah, I mean,
Okay.
I think we could probably come up with that number in an hour.
Great, okay. So
It's not
we'll,
terribly difficult.
yeah, so we'll hear back from however that conversation goes.
Yeah.
Yes, go ahead.
Fast to follow. So this is for the initial plan. Is there a higher goal for the permanent plan?
So the permanent plan allowed them to propose it.
I see, that's part of the plan, is to
Yeah.
propose what they think they could do for
Yeah.
participation. I
And
see.
so that would be at A&R's discretion as to whether or not that was a reasonable proposal. And I think that would,
You bet.
Remind me, just because I've been through a couple of EPRs at this point, is there an escalation of that? There's the intention for that to escalate?
there is not, the hope is that people don't need household hazardous waste disposal, so we don't want to get in the way of that ideal
Right.
situation. We just don't, if they don't reach the goal, they have to do more education, maybe increase hours in collection events, that kind of thing. We want to see that happen if we're not serving Vermonters completely well.
Yeah, go ahead.
Was part of it. Remind me, what happens in the permanent plan? You just set it, they get to set their own.
The permanent plan, they can set their own goal, yeah,
Who is,
and that is
the manufacturers get to set. their own
correct, the
goal?
producer responsibility organization that represents the manufacturers will write the plan and say, here's where we're gonna collect, here's our education plan, here's how much we'll.
But the plan has to be approved.
Has to be approved by A&R.
Okay, that's right.
That's right.
I remember just coming back to me now, you're seeing the 5% initially, thinking that's like really low. And then realizing
It is.
it's actually is and it isn't, because we all go like, well, if I finally get around to it every 5 years, and that's gonna
Right.
go into. and that's-
Exactly.
So that's what happens.
Yeah, the math shows, the math basically shows that if you have we have about a 12 or 13% participation rate at the Chittenden Solid Waste District. that is almost the highest we can achieve from both looking at other programs nationally as well as doing the sort of math around how frequent and actually there's a fairly, there's around 15 to 20% of the population who doesn't generate also hazardous waste within situations where they don't use it. Yeah.
Great.
I was hoping for like paint, just so it's usually paint.
Any other questions?
So another comment, just on the conversation about, so EPR, this program can be a revenue. It is and isn't, I just want to be careful about that because we don't see it as a real revenue, it's just taking on some of the costs that we would have otherwise had, which is a little bit. It's not a money maker, so to speak, I just want to make that clear. We definitely have revenue streams in our budget for EPR programs, but on the other expense side, we have more expense generally than we have the revenue for those programs. And then I'm just gonna put this out there. I don't know the timing of this bill in this committee, but SWMEs have been really struggling with pesticide disposal and the escalating costs of pesticides. And this is, of course, one of the most toxic materials in the environment. Back when we were working on these household hazardous waste EPR bills, we worked with the Agency of Ag and discussed should they be in, should we be out. And they're out. The Agency of Ag does fund us for some of our pesticide disposal, but over time that has become really inadequate. So we have I think it's a 3-year grant period for pesticide disposal. At CSWD, we spend it in 6 months. So the Agency of Ag is very interested in helping the situation and coming up with some resolution, but we've been talking about it for quite a few years. So one idea is that perhaps we put something in here that is a requirement that we work with the agency and come up with a proposal to this meeting next year and consider EPR as specifically. And I think they would be open to considering EPR, have conversations with them about that. But we just haven't gotten off the ground with it. So every time I talk about the HHW EPR law with SWMEs, they said, what about pesticides? Can we get pesticides back in and not exempt them? And I don't think that's the way to go. I think they need their own separate bill that is the agent overseen by the Agency of Ag and not the agency.
So a topic for a future bill, perhaps. Yeah. Okay. Yes, go ahead.
Just a question, I'm looking at the municipal side of this, that people show up with something they assume is a chemical, it's probably been there on the farm for 50 years, but it's not in the package, doesn't have what it is, so they won't take it. And I know what happens if they want to get rid of it, they don't take it, it goes out the car door and went home. So is there some way we can get, they're not, municipalities not gonna take the time or the expense to have that tested to find out what it is. Is there a procedure that I'm not familiar with?
So it depends on the municipality. At Chittenden Waste District, we do because we have a permanent program and we have some basic testing that we can do to at least categorize it and safely ship it off.
Yeah.
The SWMEs that do collection events, generally it's like on the spot, you can't handle it safely. So they refuse it.
And they're only there for a couple hours.
Right.
On a Saturday or whatever.
Right.
So people are gonna either take it home and put it back on the shelf or not.
I don't have an answer for you. I know that with the EPR programs, we do require the material to be in its original labeled container.
Right.
Otherwise, the producers can't really attribute that waste to a proper producer. So it does require orphan products, which are mostly businesses that have gone out of business. And it's considered an orphan, that must be included, as long as it's labeled in an original container, but this is a public safety issue. And I don't have an answer from how.
I guess it's a safety issue for people that collecting stuff too,
Yeah.
you know.
Exactly.
Yes.
So just to follow up, so if it doesn't have a clear package, it's not considered orphaned. Which is covered, like orphan projects are covered by the storage
Are covered,
Yeah.
but that's, you know what it is, and it's in its original.
I have another question about the battery EPR actually, but if there's anything else on this, sorry, and also if you have more to go.
No, that's all I have, thank you.
Great, so with the battery EPR, that is, the stewardship organization is being delayed a year. Mostly to coordinate, it sounds like with other states that are doing similar work, that seems logical and great. I'm recalling testimony about the battery EPR. Are you all continuing to have issues with rechargeable batteries at your facilities? I guess this is a question for both of you.
Yeah, so the language in H 319 doesn't delay anything in terms of the battery EPR.
Oh, okay,
law.
it's
It's just the report.
okay.
And it's just matching up with the other states that we basically took the language from Washington State when we were working on this bill, the battery bill, to do the same study, and it studies the automotive, the larger format batteries that come in cars or are storage batteries or are part of a product that you can't easily remove them. So we need a study for that to figure out how to go about that, because it did fit into the EPR bill for battery.
Right, these were the things that didn't,
Right.
that were hard to recycle.
So in 2013 or 14, Vermont passed the first primary EPR battery law, which is like the outline. And at that time, that was really the big deal because there's lots of them, they're going to the landfill and they could be recycled. And rechargeable batteries were being collected under a voluntary solution program that had been around for like 20 years. But lithium ion batteries were just up and coming, and those are the ones that have created the problem. So in 2000, last year, we added the lithium ions to the EPR program for batteries. And yes, we're still having problems because they create fires, particularly in our materials recycling facility, which is where all of the looping recyclables go for sorting, and people put them in their blue bin, which is wrong. And they end up on the tip floor and get run over by heavy equipment, and that causes them to spark and catch fire. So that happens weekly at the MRF. And we've had one significant fire. Memorial had a very significant fire in one of their trailers. I'm not sure what their has experienced.
We haven't had any fires,
That's good.
So
but it's a known risk.
it's gonna continue to be a problem. We're excited about the implementation of the new program, which will start happening next year, because there'll be more education out there about lithium ion batteries are wonderful. We just need to manage them properly. Yeah. Thanks.
Super, any other questions? All right, super. Someday I will get the timing, right? Oh, yeah, sorry, would you?
Can I join you or?
If you would like, yeah,
I'll be very, very brief.
yes.
This is on the bill, regarding the bill before you. So my name is Allison Crowley. with probably consulting government relations, and I'm wearing a couple of hats now, maybe less than 5 minutes.
Oh, yeah.
So I appreciate you fitting me in really quickly on this bill. So the overall bill before you, I represent the Household and Commercial Products Association, which is the trade association of a lot of the products that are captured under this bill under traditional household hazardous waste. And I appreciate the extensions that are in this bill. As Ms. Holliday alluded to, this is a first in the nation HHW law, and when you're getting a bunch of different producers together to figure out how this one's going to work, it does take some time. So I don't necessarily feel that we're dragging our feet. We've had Matt can back me up on this. We've had bi-weekly meetings with A&R over the whole summer and fall to try and figure out how we can do this. So we thank you for the time and we fully support that section of the bill. The bill before you, as it came over from the House, though, did have one section that was stricken from it, and that does pertain to the paint recycling program. Vermont currently has I represent the American Coatings Association, which is a trade association of paint manufacturers, Sherwin-Williams and others. The American Coatings Association runs the Paint Care stewardship organization. So Vermont currently has a stewardship organization that picks up works with the solid waste district to take back paint programs. The proposal that we sought with the agency and the House committee was to expand the scope of the existing paint care stewardship organization to have paint related products fall under that, like aerosols and paint thinners, shellacs, other types of paint related products. So the bill in House Natural was coming up against the crossover deadline, and so there were members of that committee who really wanted to delve more into the paint care proposal, but to meet the paint care, to meet the crossover deadline, they agreed to strike the paint care provision, but with the caveat that over in the Senate, we would take some more testimony and time on that because we feel, paint care feels that we would be able to really work well with the swimmies and make a very a good proposal to them. I was a little surprised that this bill was being taken up so soon before it came over to the Senate. So I do want to meet quickly with Jennifer Holliday and Theron after this to set up a meeting with them and the swimmies to talk about a proposal that paint care would like to make to them to further hopefully put the paint care section back into this bill. So my comments are really held as a placeholder for further discussion. But over on the House side, they really were looking to continue discussions on paint care proposal between the swimmies and the manufacturers. So thank you for that.
Yeah, one of the things that I feel like I heard in testimony is the difference in the reimbursement, the payment. So appreciate that you want to have more conversations with folks, but I mean, that's going to be something that rises to the top for me anyway, about making sure that municipalities, the swimmies are made whole for their work. And so, as you have that conversation, just know that that's going to be a high priority.
Of course, it's top of mind for us, and we've had some discussions internally, and look forward to further discussions with the agency and the swimmies.
And
soon.
Yeah, soon. That was because I am hoping to move this bill. Somewhat quickly.
Understood. Great. So thank you for fitting me.
Great. Thank you. All right, and so we don't have any further witnesses for today. Someday I will get the timing of when this is right, but I thought, with so many people testifying today, it might go longer. But so with that, we will adjourn for the day. Thank you, everyone.
Thank you.
All right.
Okay.
Are we adjourned?